My lord, I plead guilty before the court.
Hi, do you know that if an accused had plead guilty before court, his lawyer can actually plea for the reduction of punishment towards him? This plea is actually being made based on mitigating factors. However, at the same time, the prosecutor also have the right to plea to increase the accused's punishment, which is supposed to be based on aggravating factors. So today, together with me this time, Muhammad ai-zudin and Muhammad Nizam 256045, we are going to discuss about mitigating and aggravating factors. Mitigating factors are the factors that should make the court to consider about the reduction of the punishment of the offender, while the aggravating factors are the factors that should make the punishment go higher. In order to understand more about these factors, let's go and see about the mitigating factors first, then we will come back for the aggravating factors. Oops, sorry. I'm really sorry, my magic pen. So now, moving on to the very first mitigating factors that can be used by the defense counsel, which is the age of the offender. So now, if the offender is still in the age of 17, 21 years old, he should be called as a young offender. So now, in the case of Tukiran bin Taib against public prosecutor, the court had agreed to reduce the punishment of these young offenders from imprisonment to only send him to a proof school, which is handwriting. So now, in this case, it is indeed that the court can reduce the punishment due to the young offenders. However, the view of this case had not been followed by all of the cases, because some of the cases in Malaysia still make the young offenders be imprisonment, such as the case of rape and also the case of drug trafficking, because the court still need to give the priority to the aim of the punishment to these young offenders. Secondly, the mitigating factors that is available for the defense counsel is the record of the previous offense. So now, if there is no criminal record on the offender, which means that this is the first time offender, it's supposed to be a good mitigating factors for the court to be considered about. For example, in the case of public prosecutor against Mark According, the court had actually found out that the accused in this case is the first time offender. So the final decision of the court is that the accused finally had been released on a good behavior bond. So this actually proved that the record of the previous offense can actually affect the decision of the court, which if the offender is the first time offender, it's supposed to be a good reason for the court to reduce his punishment. Next, we move to the gap principle. So now, if this accused had somehow made an offense in his past, and now he also made an offense, but there is a gap of time between the previous and also the current offense, well, in this principle, the court shall disregard the previous offense and next treated the offender as a man of good character. So this situation actually can be viewed in the case of So Sai Nathan against public prosecutor, where in this case there is a gap between the previous conviction and also the current offense. So for the court in this case, it had been held that the court had viewed this gap of time as a mitigating factor rather than an aggravating factor. The longer the gap, the greater the mitigating factor. So in this case, it had been proved that the gap principle should help the court to consider about the reduction of the punishment towards the offender. Moving on, there are certain circumstances before offender committing the offences that can be considered by the court to be a good mitigating factors, which are the first one is drunkenness. Now, in the case of ai-zudin against public prosecutor, the accused was drunk before he actually slapped the police officer, and then he had been sentenced to 3 years of imprisonment. However, because the court had considered that the accused was drunk and not really realized what he is doing, so the the imprisonment, the punishment of imprisonment had been substituted with a bond of good behavior, and the accused need to pay the compensation to the victim. So this is how the court will consider about the reduction of punishment. Other than drunkenness, there are also, if the person is being provoked before he actually commit the crime, it also can be considered by the court. So now, in the case of public prosecutor against Mat Dahlan and others, this is a murder case. This murder case had actually made the accused had been charged with murder under section 302 of the penal code. However, in this case, the court had found out that the accused had been provoked so badly before he commit the crime. So now, because of the court had considered that provocation somehow can be a good mitigating factors, the court had actually, instead of being punished by 302 of the penal code, he had been punished of the offence under section 304 of the penal code, which considering the facts that provocation is the act of others that cause the offender to retaliate and commit a crime. So it is not based on himself only, but he has been provoked. So now, the next circumstances that should be considered by the court before committing the crime is the consent. Usually, this consent is being considered in the case of rape. So, these circumstances can be considered by the court, not all, but these three are the example of the circumstances before committing a crime can be a good mitigating factors for the court to be considered about. Next, mitigating factors that can be used by the defense counsel is the conduct of the offender himself. So now, if the offender had actually prevailed some of the good convincing acts, such as the act of repentance or the act of willingness to cooperate with the police officer, the court should consider this as a good mitigating factors, and this actually show that the accused now had tried to prove himself to a good manner. So now, for example, in the case of Raja Izzuddin Shah just now, after the accused other than being proved to be drunkenness, the accused also had shown the act of repentance, regret of his wrongdoings. So for the court, this is a good mitigating factors. Other than that, in the case of public prosecutor against Manhan Return, the accused in this case actually proved to the court that he is willing to cooperate with the police, so that to get the other evidence that can actually help the case to being proved before the court. So the conduct of the offender also can be a good mitigating factor. Plead guilty is one of the common mitigating factors that have been brought by the defense counsel. So in this situation, an offender usually will admit to the court of his crime doings, and this can make the judges to consider about the reduction of his punishment. For example, in the case of public prosecutor against Syaritan, anak lelaki Pacu itu, the accused himself had actually made admission about his crime, and the court accept it as it is related with the fact of the case, and the court had reduced the punishment of him, which is imprisonment years, quarter of his imprisonment years. The court had reduced it to 6 years. So, act of pleading of guilty can be considered a good mitigating factors before the court. Last but not least, the mitigating factors that is available for the defense counsel is the effect of the punishment towards the life of the offender. Now, if it is reasonable for the court to actually reduce the punishment towards the offender, if somehow the punishment can actually affect his reputation or can cause the hardship on the living of the offender's family. Sounds illogical for you? It had been shown in the case of Jan Sidhu against public prosecutor, when in this case the accused had been sentenced to imprisonment for 1 year. However, the court had actually seen that this punishment was too excessive. Why? Because the offender was the first time offender, and also he has actually one wife and also 5 children to support. If somehow this punishment being imposed towards him, his family will be affected so much just because of his punishment. So, the effect of this punishment also can be a good mitigating factors for the court to be considered about. Not again. I'm so sorry. Wait for a minute. I'm so sorry. Again, my magic pen. So now, moving on to the second part of the discussion today, which are the aggravating factors that are available for the prosecution can make the punishment go higher. The very first aggravating factors that can be discussed today is about the previous conviction or bad record. So now, previous conviction, if somehow the offender have the previous convictions being imposed towards him or bad record, it should be relevant if it is being tendered before court. If the evidence, this type of evidence of bad character being tendered is relevant with the fact of the issue, because it is related with the section 54 of the Evidence Act, which say like this. So the evidence of bad character can be tendered before court and can be a good aggravating factors that can be used by the prosecution, and it should be made for the court to make the punishment go higher. Moving on to the second aggravating factors that is available for the prosecution is the use of force by the offender. So now, in this situation, if the accused somehow had performed any excessive use of force or violence in performing his criminal action towards the victim, the heavier sentence should be imposed towards him. For example, in the case of Ahmad Nazri bin Abdul Majid against public prosecutor, it is a rape case where the accused in this case had actually raped his victim with use of violence, which is excessive force, and also use a weapon to threaten the victim. So in this situation, the court had seen that the action of threaten the victim with a knife, a weapon, and also use excessive force by punching and also struggling with the victim, it had been seen that it should be a heavier punishment be imposed towards the accused. So now, the use of force or use of excessive force can be a good aggravating factors. Next, mode of committing offense by the offender also can be a good aggravating factors for the prosecution to use to make the punishment go higher. Because in this situation, if the offense being committed by the offender with a brutality, it is relevant for the court to increase his punishment. Now, such as in the case of public prosecutor against Safian bin Abdullah and another, the victim had wounded so badly, and suddenly the accused had made the victim was brutally strangled with a rope. So in this case, the court had actually imposed a maximum sentence of 14 years imprisonment towards the accused. So if the offense had been committed with brutality, there is no chance for the accused to decrease the punishment, but the punishment should go higher. Position of the offender also can be a good aggravating factors for the prosecution to use. So, a position of a person represents his obligation. The higher the position, the higher the obligation of a person indeed. So, if the offender had the high status in a case, the offender should be the punishment for the offender should be aggravated, as he should to be expected not to commit the crime that he done. For example, in the case of public prosecutor against ai-zudin, the court in this case had decided to increase the punishment of the offender to 18 months of imprisonment plus with a fine of 2,000 ringgit, because he is the credit of the controller of the bank and he was betrayed the trust that was given to him. So the higher position you are, you should be more extra careful. The last but not least, the aggravating factors that is available for the prosecutor is the rampancy of the offense. So now, if the offender had committed a crime that can be seen by the court as a rampancy offense, the court should impose the heavier punishment. The purpose of this heavier punishment is that to be a lesson for the public to not commit the crime or to not commit the same offense. For example, in the case of Lee Chow Meng against public prosecutor, the court had considered that the armed robbery as a rampancy offense. Why? Because it looked like gang robbery or armed robbery as a pandemic in this country. So the court had imposed a heavier punishment, which the court had gave a punishment of imprisonment, whipping, and also fine to the accused, which the case was appealed, and again the court in the appeal and also High Court had also give the same punishment because of the seriousness of the offense. So rampancy of offense should be considered as a good aggravating factors that can be used by the prosecution. So in conclusion, the defense counsel and prosecution have the right to plead before the court about the mitigating or aggravating factors to reduce or increase the punishment. However, the court will need to look into the seriousness of the offence that being committed by the offender, and next make the decision based on the direction of the justice first. So if you want to understand more about the mitigating and also aggravating factors, don't forget to comment below that you want for my infographic poster about mitigating and aggravating factors. I think that's all for today's discussion. Thank you very much for watching. Bye bye.